And the Nick, the viewer is asking for some advice. She states that she's in the process of moving into a new home that she'll be renting. They've signed a lease agreement, which was yesterday, but today they've found a better place to stay. She has made contact with the agent today, informing him that she's no longer interested in the place that she had signed the lease agreement for. Seeing that she does have a cooling period, she states that she's got a cooling off period. She states that the contract can be cancelled. She did pay the application fee. However, now the agent is insisting that she must pay an admin fee of 1,500 Rand. The admin fee was in the contract and should have been paid with the deposit and the first month's rental, obviously. The question then is she legally obliged to pay the 1.5 for them setting up the lease agreement and for doing some admin work? So yeah, Nick, just take us through that, please.
Okay, so the real question here is about the validity of the contract and the circumstances. It seems to me quite clear. The writer says that the 1,500 Rand administration fee was in the lease agreement, and she's not trying to tackle the enforceability of that necessarily, or the reasonableness of that. That seems to be pretty clear that would be paid depending on the status of the contract. Now, what the writer says is, the writer makes the assertion that they have a cooling off period, okay, and can therefore cancel the lease agreement. Now, that's where the crux of this particular matter exists for me. Right, now a cooling off period for our viewers is basically a short period in which the law allows someone to back out of a particular contract. Okay, this is not a universal thing. Okay, it's a very specific thing that occurs only in very specific situations that are allowed in law. Okay, so I don't want people to think that you have cooling off contracts for every single contract that you ever into. Okay, certainly 99% of contracts that you enter into ever are not going to be subject to a cooling off period. Okay, you cannot simply go take back your groceries after a day after you buy them from the shops. All right, there's no such thing as a cooling off period. The only place that in law really allows for a cooling off period is in respect of contracts that are entered into by direct marketing. Okay, so what do I mean by this? Direct marketing are contracts that are entered into where the person who is trying to provide you with goods or services directly contacts you in order to induce you to enter into that contract. Okay. The best example of these direct contracts are, for instance, you get telecom salesmen who call you all the time and want to give you the best new thing from, I won't mention which company, but we all know what I'm talking about. All right. These guys call you constantly and they always tell you they've got a great deal and they just want you to sign up right now. And all you need to do is give them a little bit of detail. That is a contract in which direct marketing is involved. Okay, they are directly contacting you to try and induce you to enter into this contract. And the law recognizes that in those particular circumstances, you might enter into a contract which after you have put down the phone or after a day or two, you go, actually, you know what, I really don't want that contract. And the Consumer Protection Act allows a time period for the cancellation of those contracts without penalty. Okay. So that's the type of contract that is subject to a cooling off period. Okay. Other than that, there are very few examples of contracts that have this cooling off period. So you can't assume that that does exist. It is possible, I suppose, to put a cooling off period clause within a lease agreement. So what we don't know in this particular question is, was there a clause in the lease agreement that allowed a cooling off period? If there was, then the writer would be, I assume, exactly right, because they are cancelling the day after signature of the contract. So it seems reasonable that a cooling off period would be at least 24 hours. But that would absolutely require that such a clause is contained within the contract. I will say from my experience, I've never seen a cooling off period within a residential or a commercial lease agreement. It's not a common clause within a lease. Doesn't mean that perhaps this agent had a phenomenally fashion forward lease agreement that contained a cooling off period or a cooling off clause, but I think it's very unlikely. I've never experienced it. I see Bruno's nodding as well, so I don't think he's experienced it. So I would caution the writer to assume that they have the right to cancel the lease agreement on the basis that there is a cooling off period. In South African law, when a contract is struck between parties, you're bound by that contract. Okay, our law doesn't allow people to simply back out, 5 minutes afterwards or a year afterwards. And the reason is we want to protect, the sanctity of contracts entered into between parties. It seems to me in this particular circumstance that the contract had been concluded. You say that, yesterday you signed this contract and you even paid a part of what was payable in terms of that contract. So it seems to me that the conduct demonstrates that the contract had in fact been concluded between the parties. And in those circumstances, you would be bound by the terms of the contract. And unfortunately, this is something that happens to a lot of people. They enter into contracts and all of a sudden the next day you find another contract which you would have perhaps selected if you hadn't concluded your contract yesterday. This happens all the time. But unfortunately, that occurring with, you finding something that might have been preferable to you does not entitle you to cancel your contract automatically and just escape without consequence. That's not how the law works in relation to contracts. Obviously, this person has other remedies available to them. They could cancel the lease agreement in terms of Section 14 of the Consumer Protection Act by giving 20 business days notice. There's no problem there. But the question here is, would they be liable for the 1,500 Rand administration fee? In which case the answer is absolutely you would. The contract, the contract has been concluded as far as I can see in terms of this question. And if that is so, and the administration fee is payable upon conclusion of the contract, then you're going to be liable for that. I don't see you escaping that. If, on the other hand, there is one note which Bruno did mention, which is clever start. If perhaps you've indicated your intention not to proceed with the contract, and the agent or the landlord in the circumstances is saying absolutely no problem, but you are going to pay for the administration fee of 1,500 Rand, it might be in your best interest to pay that and walk away from the contract, because in truth, I think you're liable for a lot more. Certainly, if you've got to give a 20 business day notice, you're going to be liable for at least 1 month's rental and reasonable cancellation penalties. If that's a negotiation and an agreement you can come on for the termination of the agreement, if you do it mutually, that might be an option for you.
Cool. So yeah, thank you very much, Nick. And then Bruno.